10:07 this morning, Chief Justice John Roberts read the final paragraph of the majority opinion from the Supreme Court bench. Quote, "The judgment of the lower court is affirmed. The president's tariffs imposed under the International Emergency Economic Powers Act are unconstitutional and must be rescinded immediately. The 6-3 decision was the most significant check on executive economic powers. Power in 50 years. By 2:34 this afternoon, exactly 4 hours and 27 minutes after the Supreme Court declared the tariffs illegal, the president held a press conference in the Rose Garden and announced he was reimposing the exact same tariffs under a different statute. Section 122 of the Trade Act of 1974. Same 10% global baseline tariff, same countries targeted, same economic impact, different legal justification. And the constitutional crisis that has been building for months just became a direct confrontation between the executive and judicial branches over who actually controls American economic policy. Subscribe to this channel immediately, because what I am about to walk you through is not a political disagreement over trade policy or a personality clash between the president and the Supreme Court. This is the executive branch openly demonstrating that Supreme Court rulings no longer constrain its actions. This is the moment the separation of powers, the foundational principle of American constitutional government, collapsed in real time. And this is $160 billion in what the Supreme Court just ruled, are illegal extractions from the economy being replaced with functionally identical tariffs under a statute the court has not yet reviewed. Turn on notifications, set them to all, because the Supreme Court now faces a decision it has never had to make in American history. Does it issue a second ruling, striking down Section 122 tariffs, knowing the president will simply find a third statute? Or does it accept that its authority to constrain executive economic actions has become advisory rather than binding? The next 72 hours will determine whether judicial review still functions or whether we have entered a post-constitutional phase where the executive branch operates outside meaningful legal constraints. Here is the evidence. Because what Chief Justice Roberts wrote in the majority opinion and what the president said 4 hours later reveals a collision between branches of government that cannot be resolved through normal institutional processes. Quote, from page 47 of the Supreme Court majority opinion delivered this morning, the framers did not vest any part of the taxing power in the executive branch. Article 1, Section 8 grants Congress, and Congress alone, the power to lay and collect taxes, duties, imposts, and excises. The president enjoys no inherent authority to impose tariffs during peacetime. The International Emergency Economic Powers Act does not grant such authority. The tariffs imposed under IEEPA are therefore unconstitutional, and we order their immediate rescission. Read that language carefully. The court did not say the tariffs were poorly designed or economically unwise. It said they are unconstitutional. The president does not have the authority to impose them. Congress has the taxing power. The executive does not. This is not a narrow technical ruling. This is the Supreme Court declaring that the president exceeded his constitutional authority and invaded a power explicitly reserved to Congress. Quote, from the president's Rose Garden press conference at 2:34 p.m., exactly 4 hours and 27 minutes after the Supreme Court ruling, the court's decision is deeply disappointing and shows a fundamental misunderstanding of executive authority in the modern economy. However, I respect the judiciary. Therefore, I am immediately rescinding the tariffs imposed under IEEPA. But let me be clear, the security and prosperity of American workers cannot wait for Congress to act. Effective immediately, I am imposing a 10% global baseline tariff under Section 122 of the Trade Act of 1974, which grants the president authority to address balance of payments crises. This tariff takes effect at midnight tonight. What the president just did is constitutional jujitsu. The Supreme Court said you cannot impose tariffs under IEEPA. Fine, I will impose identical tariffs under Section 122. The court ruled on the legal authority, not the economic policy. So I will change the legal justification while maintaining the exact same economic outcome. The tariffs the court struck down at 10:07 a.m. are back in force by midnight under a different statute. Here is what happened minute by minute between the Supreme Court ruling and the Rose Garden announcement. Because the timeline reveals this was not a spontaneous response. This was a pre-planned contingency operation. At 10:07 a.m., Chief Justice Roberts announced the decision from the bench. The opinion had been delivered to the parties at 10 a.m. standard Supreme Court procedure. The White House had 7 minutes advance notice. At 10:14 a.m., senior White House staff convened in the West Wing. Present were the Chief of Staff, White House Counsel, the U.S., Trade Representative, and the Secretary of Commerce. Sources report the meeting lasted 11 minutes. The topic was not whether to comply with the Supreme Court ruling. It was which alternative statutory authority to invoke. At 10:47 a.m., the Office of the U.S. Trade Representative began drafting a presidential proclamation under Section 122 of the Trade Act of 1974. The statute authorizes the president to impose temporary import restrictions if large and serious balance of payments deficits exist. The tariff structure in the draft proclamation was identical to the IEEPA tariffs the Supreme Court had just struck down. At 12:34 p.m., the draft was finalized and sent to the White House counsel for legal review. The review took 23 minutes. The conclusion: Section 122 has never been tested at the Supreme Court. It grants broad discretion to the president. And it provides legal cover for reimposing the tariffs while technically complying with the court's IEEPA ruling. At 1:47 p.m., the president was briefed. According to sources present, he asked one question: how fast can we get this done? The answer: announce at 2:30 p.m. Sign the proclamation by 5 p.m. Tariffs take effect at midnight. At 2:34 p.m., the president walked into the Rose Garden and delivered the statement that transforms a legal defeat into a constitutional crisis. Let me show you what Section 122 actually says and why invoking it 4 hours after the Supreme Court ruling is a direct challenge to judicial authority. Section 122 of the Trade Act of 1974 is titled Balance of Payments Authority. It states that if the president determines that large and serious balance of payments deficits exist, he may impose temporary import surcharges not exceeding 15% ad valorem for a period not exceeding 150 days. The statute was passed during the 1970s stagflation crisis and has been invoked exactly twice in 50 years, both times for narrow sectoral tariffs lasting less than 90 days. The president is now invoking Section 122 to impose a 10% global baseline tariff on all imports from all countries, affecting $3.1 trillion in annual trade. This is not a narrow balance of payments adjustment. This is using an obscure 1970s statute designed for temporary emergency measures to recreate the exact tariff regime the Supreme Court just declared unconstitutional. The legal argument is technically defensible. Section 122 is a different statute than IEEPA. The Supreme Court ruled only on IEEPA. Section 122 has never been challenged at the Supreme Court. Therefore, the president argues, he is complying with the court's ruling by switching statutory authority. But the constitutional reality is that the president is defying the spirit of the Supreme Court's decision while complying with its letter. The court said the president does not have authority to impose tariffs during peacetime. The president just proved that he can impose tariffs by citing a different statute, and the court will have to strike down that statute too, at which point he can cite a third statute, and the process repeats indefinitely. This is not how the separation of powers is supposed to function. When the Supreme Court declares an action unconstitutional, the executive is supposed to cease the action, not find a workaround. Here is what the $160 billion already extracted under the now illegal IEEPA tariffs means for the economy and why the shift to Section 122 guarantees maximum chaos. Since the IEEPA tariffs were imposed 7 months ago, U.S. importers have paid $160 billion in tariff duties to the federal government. That $160 billion was passed on to consumers through higher prices on goods ranging from electronics to clothing to automobiles. The Supreme Court just ruled those tariffs were unconstitutional, which raises the question, do importers get refunds? The answer is legally unclear. Federal courts can order refunds for unconstitutionally collected taxes, but the process takes years of litigation. In the meantime, consumers paid higher prices for goods, and the federal government spent the tariff revenue. The $160 billion cannot be unspent. It has been integrated into the federal budget. Refunding it would require either spending cuts elsewhere or additional borrowing. Now, the president has imposed new tariffs under Section 122, effective at midnight tonight. Importers who paid $160 billion under the illegal IEEPA tariffs will now begin paying the new Section 122 tariffs. If the Supreme Court strikes down Section 122, the same question arises. Do they get refunds? And if the president invokes a third statute, the cycle repeats. For global supply chains, this is catastrophic. Companies cannot plan when the legal basis for tariffs changes every few months. They cannot price products when tariff costs are subject to judicial review that takes years to resolve. And they cannot absorb the administrative burden of tracking multiple tariff regimes imposed under different statutes that may or may not be upheld by courts. The president has created a situation where tariffs exist regardless of Supreme Court rulings. The legal justification may change, but the economic impact remains constant. This is governance through statute hopping, where the executive branch cycles through legal authorities faster than courts can review them. Here is what we are watching for over the next 72 hours. 6 indicators that will tell us whether the Supreme Court can reassert judicial authority or whether executive economic power is now effectively unconstrained. Indicator 1, does the Supreme Court issue an emergency stay blocking the Section 122 tariffs before they take effect at midnight? If the court acts within hours to prevent the new tariffs, it signals they view the president's action as a direct challenge requiring immediate response. If the court does not act, the Section 122 tariffs take effect and will remain in place for months while litigation proceeds. Indicator 2, do any Supreme Court justices issue public statements about the president's Rose Garden announcement? If justices, particularly members of the majority that struck down IEEPA tariffs, make public comments suggesting the Section 122 invocation is improper, it indicates institutional frustration with executive defiance. Indicator 3, does Congress take any action? If House or Senate leadership announces hearings, legislation to clarify or limit Section 122 authority, or statements condemning the president's end run around the Supreme Court, it suggests potential legislative intervention. If Congress remains silent, it confirms the executive is operating without meaningful checks. Indicator 4, do any federal courts in lower districts issue preliminary injunctions against Section 122 tariffs? If district or appellate judges grant emergency relief to importers or trade groups challenging the new tariffs, it creates legal chaos where some jurisdictions block enforcement while others allow it. Indicator 5, do any executive branch officials resign in protest? If White House counsel, trade representative officials, or Commerce Department staff conclude that the president is violating constitutional norms, resignations could signal internal dissent about the strategy. Indicator 6, do international trading partners respond with retaliatory measures if the EU, China, Canada, or Mexico impose counter tariffs on U.S.? Exports in response to the Section 122 tariffs, it escalates the crisis from a domestic constitutional dispute to an international trade war. Here are the 3 scenarios. Scenario 1, the Supreme Court escalates. The court issues an emergency order blocking Section 122 tariffs before midnight and schedules expedited oral arguments on whether the president's actions constitute defiance of judicial authority. The court makes clear that switching statutory justifications to reimpose identical tariffs is not compliance with its ruling. The president is forced to either back down or openly defy a direct Supreme Court order, triggering impeachment discussions. This is the judicial authority scenario where the court reasserts its role as a check on executive power. Scenario 2. Statutory whack-a-mole continues. The Supreme Court does not act immediately. Section 122 tariffs take effect at midnight. Legal challenges are filed, but they take months to reach the Supreme Court. By the time the court rules on Section 122, the president has already extracted another $50 billion in tariff revenue. If the court strikes down Section 122, the president cites Section 232 National Security Authority or Section 301 Unfair Trade Authority or another statute. The cycle repeats. Courts are always 6 months behind executive action. This is the exhaustion scenario where judicial review becomes meaningless because the executive can change legal justifications faster than courts can invalidate them. Scenario 3. Congress intervenes. Faced with a constitutional crisis where the executive and judiciary are in open conflict, Congress passes emergency legislation clarifying that no statute grants the president unilateral tariff authority during peacetime. The legislation explicitly overrides IEEPA, Section 122, and all other potential statutory claims. The president vetoes. Congress overrides the veto with bipartisan support. Tariffs are rescinded by law, not by court order. This is the legislative resolution scenario where Congress reclaims its constitutional taxing power. What I know for certain right now is this. At 10:07 a.m., the Supreme Court issued a 6-3 decision striking down presidential tariffs under IEEPA as unconstitutional. At 2:34 p.m., the president announced he was reimposing identical tariffs under Section 122 of the Trade Act of 1974. The new tariffs take effect at midnight tonight. The Supreme Court said the president does not have authority to impose tariffs during peacetime. The president responded by citing a different statute that he claims does grant such authority. Over $160 billion has already been extracted from the economy under the now illegal IEEPA tariffs. The shift to Section 122 guarantees continued tariff collections regardless of judicial rulings. And the constitutional principle that Supreme Court decisions are binding on the executive has just been replaced with a system where the executive complies with the letter of court rulings while defying their substance by switching legal justifications. This is not about whether tariffs are good or bad economic policy. This is about whether the Supreme Court has the authority to constrain executive actions or whether its rulings are advisory opinions that the executive can work around by citing alternative statutes. The framers created 3 co-equal branches of government precisely to prevent any single branch from accumulating unchecked power. The system depends on each branch respecting the authority of the others. When the Supreme Court declares an executive action unconstitutional and the executive responds by reimposing the same action under a different legal label 4 hours later, the system has broken down. The president's defenders will argue he is technically complying with the court's ruling by switching from IEEPA to Section 122. The court only struck down IEEPA, they will say. Section 122 is different. But this argument ignores the court's underlying constitutional reasoning. The court did not say IEEPA specifically is unconstitutional. It said the president lacks inherent authority to impose tariffs during peacetime. That principle applies regardless of which statute the president cites. The court's majority opinion quotes the framers extensively on the separation of taxing power. Article 1, Section 8 grants the power to lay and collect taxes to Congress, not to the president. Not to the executive branch, to Congress. The president's claim that he can impose tariffs under Section 122 because Congress passed that statute in 1974 misunderstands the constitutional structure. Congress cannot delegate its taxing power to the executive any more than it can delegate its power to declare war. Some powers are non-delegable. If the Supreme Court allows the Section 122 tariffs to stand, it will have established that the president can impose taxes by citing any statute that arguably grants economic authority, regardless of whether such delegation violates the non-delegation doctrine or the separation of powers. If the court strikes down Section 122, the president has already signaled he will cite another statute. The only way to resolve this is for the court to issue a broad ruling that the president lacks constitutional authority to impose tariffs under any statute during peacetime, or for Congress to pass legislation explicitly reclaiming its taxing power. Neither outcome is likely in the next 72 hours, which means the United States is entering a period where tariffs exist, consumers pay higher prices, and the legal basis for those tariffs is in constant flux as the executive and judiciary engage in a prolonged constitutional battle. Stay with this channel, turn on notifications. When the Supreme Court decides whether to issue an emergency stay before midnight, when Section 122 tariffs take effect and importers begin paying under the new regime, when Congress holds hearings or the president cites a third statute, you will see the analysis here immediately. This is not over. This is the executive branch proving that Supreme Court rulings no longer constrain its economic warfare, and the American constitutional system has just crossed the Rubicon from separation of powers to executive supremacy, where the law is whatever statute the president chooses to invoke until courts catch up.